Well, good afternoon. This is Kevin Snyder over here at Snyder Law, and we're going to be visiting today again with another weekly installation of Nuggets of Knowledge. And I'd like to follow up from last week a little bit. We were talking about what really happens if you're in a coma. We're going to continue that conversation because I've been getting a lot of great feedback this week. And people want to know what a healthcare directive is, and do I need that in order to prevent that situation you were talking about last week, Kevin. So let's dive into that. So what is a healthcare directive exactly? Well, it's known by a variety of different forms. It kind of generically describes the information and instructions about your healthcare and who you are appointing as a decision maker to make certain decisions. So that's generally what a directive is, but there are specific documents that each state calls them something a little bit different. We'll talk about California. In California, we have an advanced healthcare directive that is much like a healthcare proxy or a durable power of attorney for healthcare. Those are some of the other names that other states give that. But an advanced healthcare directive here in California is the legal document where you name decision makers, or a decision maker at the very least, to make decisions for you in the event that you're incapacitated and lack the ability to communicate and make those decisions. And of course, advisable for you to name more than just one person and have a good backup if possible. The other document that is a part of a healthcare directive is your HIPAA waiver. What's a HIPAA waiver? Well, it's your authorization for release of medical information. Your medical information is protected health information, PHI, under the HIPAA laws. And so in order for your healthcare agents or anybody to get information regarding your health, which would be protected health information, you need to have this waiver or release. And the last is what we call a living will. And a living will is a document where you state your wishes about life-sustaining medical treatment if you're terminally ill, if you're incapacitated and permanently unconscious, that's called a persistent vegetative state, or you're incapacitated and you're at the end stages of a fatal illness. What are your decisions and instructions regarding life-sustaining treatment there? I.e., do you want to be kept on life support or removed from life support? And you put those decisions in a living will. Because if you don't have these healthcare directives, your advanced healthcare directive and your living will, as well as your HIPAA waiver, kind of sorted out and legally done and properly done, then it could create that mess we were talking about last week if you're in a coma and you're not able to communicate yourself. So I thought we'd take this time to follow up a little bit on some of the myths. This will be like a Mythbuster episode, because in having these good conversations in the last week, for those that watched the last episode and just in general when I'm meeting with clients, of course we always talk about the importance of planning for the event of incapacity, your incapacitation planning. And so we have these discussions, and naturally we all have these understandings, conventional wisdom, if you will, these myths that are out there, urban legends about what happens. And I'd like to just take some time to take a few of these out and see if we can do a little bit of myth busting. So one is you have to use your state's own statutory form in order for your directive to be valid. That is a myth. The states don't have a requirement to use a particular form. Most states have their forms are kind of general and broad and encompassing, so that if you were in any state, if you used a general form, it might apply. The problem, however, comes in not that I live in California, I set up my directive here, and now I'm in Arizona when something happens. And Arizona doctors aren't going to follow the directive and listen to my agents that my decision makers that I've named. The problem more is that these universal state documents aren't specific enough for your needs. They're very wide-reaching and broad, and they're not tailored specifically to you. So that's more of the issue. So yes, you can create an advanced healthcare directive in California and be traveling in another state. Something happens, and you should be fine. The issue is more Does your planning specifically demonstrate your wishes? Is that known across the board? The other myth is an advance directive, that means do not treat, right? No, that is something that's different as well. An advance directive are your decisions of who your decision makers will be, who your healthcare agents will be to carry out your instructions. A do not resuscitate, that is something that's different. And you may have heard of POLST or POLST document. A number of states have adopted those. And a do not resuscitate is something that has to be expressly filled out and properly. So it's different from an advance directive. So that is completely different. If you want to do not resuscitate form that you can have and have the bracelet, have it posted on a prominent place in your home, if you're home, then that's an entirely different type of legal document and process. Just talking to my doctor and family about what I want is not legally effective. That is true. Just talking to your doctor and your family about what you want isn't going to be legally binding. So that's not necessarily a myth. That's true. Because if you talk to your husband, your wife, or your adult children, or you talk to your doctor, that's going to be helpful. And we certainly encourage you to do that. It absolutely is necessary, and I say as a supplement to the legal documents. When we talk to clients, that's great. You have something in writing. This is your plan. But now, is your plan accessible? Is it going to be accessed? And we talked about that last week with the emergency cards. That's one way to make your plan accessible to first responders, to have an emergency card in your wallet that gives access to your important healthcare documents and your incapacitation planning. That's something that we do for our clients. But in addition to that is having the necessary conversations with your family, those people that you're naming agents, your doctors, making sure that they truly understand where you're coming from, because it might say it on a piece of paper, but if you're not tying them into that, they might disagree. There could be some issues. There could be some confusion sometimes over the language that's used in the document. So we want to flush that out. And that's something that we talk with clients revisiting every year when we meet with them at their annual meetings. Is, have you had the conversation with your family? Have you talked and looped in your doctors? And if so, how do they think that might sound better, or especially from a doctor's perspective, maybe we need to tailor some of the instructions a little bit. Myth number 3, once I give my advance directive to my doctor, I'm all set and done. Well, as we just talked about, we want to make your plan accessible. So this is a myth. You can fill out an advance directive and give it to your doctor, but you're not done. While the directive will stay in place and will be valid over time, and it's not going to become invalid because time passes, your wishes, however, your instructions may change. So if you're not going back and updating your advanced directives, either your living will or your advanced healthcare directive here in California, then what you have put down on paper 5, 10, 15, 20 years ago might not be what you currently want to do anymore. So it's important for you to revisit that and make sure that your treatment providers have the most updated copy. And the last myth that I'm going to share with you is advanced directives are only for the elderly. Is that true? Is that not true? Well, of course, it's not true. So that's a myth. And here's why. A lot of you who might be watching this remember a woman by the name of Terri Schiavo. And Terri Schiavo was in the news. Why? Because Terri was in a persistent vegetative state for a number of years, and her family, her husband, and her parents were fighting in court for over 15 years to determine whether or not Terri was going to remain on life support or be removed from life support. And I bring up the fact that Terri is a great example of why doing your advanced directives is not just for elderly, because Terri was only 26 years old at the time that she had a stroke, and which led to her brain damage, which ultimately led to her to be in this persistent vegetative state and the subsequent litigation. So here is somebody who's 26. Think back to when you were 26. And maybe you're watching this and you are 26. Or think about that time in your life. Probably weren't thinking about putting together advanced directives, probably weren't thinking about your life ending anytime soon. That's a human condition. Where the younger we are, the more invincible we seem. But the fact remains that that's just patently not true, and all of us know that on some level. We just don't like to, as humans, recognize that, of course. But so it's really important, even for young people, to be putting together their wishes so that if something happens to them, their wishes can be carried out, or that people can, their family members can, make decisions for themselves. So you don't have a situation like Terry Schiavo, where you have a husband and parents disagreeing over what Terry's true wishes are. And this is for anybody who is an adult. So if you're 18, guess what? You're now an adult, and your parents can't act on your behalf anymore. And if you were to have a situation when you're at school or whatever you're doing, if you're still in high school, you're out of college, you're taking a gap year, you're working, and you need some medical attention, but you can't communicate because you're incapacitated, who's going to make that decision for you? The power and authority doesn't inherently rest in your parents anymore, although they've raised you all these years. Once you're 18, then the law says, you know what, you have adult responsibility now. With adult responsibility comes adult power, and you are in charge of making your own decisions. So for parents out there with those children that are 18 years old and older, something to consider strongly of getting your advanced directives in place for your adult children as well, so that you can continue to be that great provider, that great support, and legally be able to make decisions for your children in the event that they're incapacitated and they can't. So those are just some myths that we today over advanced directives, what they are, why you should do them, why you shouldn't. And I think the overall conclusion in this is have the conversations. Start there, have the conversations, but don't let it stop there, because just because you talked about it doesn't make it be. So follow that through. Put together your advanced directives, your advanced healthcare directive, your living will, get your HIPAA waivers out there, consider an emergency card, make this a holistic plan. And then you can sit back and feel comfortable and having that peace of mind that no matter what happens today, that you're covered. Okay, so thank you for your time. Always a pleasure. Glad to be here this week and looking forward to next week. So catch us on Facebook, on our Facebook page here. Like us. Send us some topics, the things to talk about. I want to address what you want to hear about. I want to answer your questions. So please, a number of you have been great. I've been having great conversations. Keep them coming. Send them to me at email, kevin@snyderlawpc.com, or right here at Facebook. Just put a comment in the video here, and I'll get it, and I will answer your question next time. All right. In the meantime, go out there, be amazing. Have a great week, and I'll see you next week. Take care.